For those of you who don't know me, my name is Ranchod. I'm an immigration lawyer. I've been practicing for over 23 years. I want to start off with the executive orders, and then we will dive into questions. We have a lot going on with humanitarian parole. So with humanitarian parole, impact advanced parole in a way. Humanitarian parole was issued to allow people from Venezuela, from Cuba, from Nicaragua to enter the United States on parole status. So basically Trump is taking that away. Now, the way that this affects advanced parole is because it's confusing. It could be confusing to an officer who doesn't understand the technicalities of immigration law. And they look at the parole status and there's just blanket orders saying, no more humanitarian parole, which was using parole status, which is similar to advanced parole. They might not be able to make the distinction between advanced parole while you have a green card application pending and humanitarian parole being rescinded. So I know we had this question earlier, like, should I travel on advanced parole when I have a green card pending? I would say definitely not right now until this all gets cleared and there's more training, because an officer making a mistake at the port of entry, not understanding what's going on, could impact whether or not you could come into the United States. So right now I would say don't travel on advanced parole unless it's absolute emergency. Humanitarian parole is not going to be reissued for countries such as Cuba, Nicaragua, Venezuela, that was issued earlier. There's an executive order basically enhancing visa vetting and screening. What that basically means is that they're just saying, we're gonna make it, we wanna make it more challenging, harder for you to get your visa. They're putting that, that's in writing right now. So basically, there's gonna be more vetting, expect more administrative processing if you're at an embassy abroad, where things are gonna get longer, take longer. Over the weekend, there was a Twitter battle between the president of Colombia and president of Trump, and then shortly thereafter, the embassies shut down in Colombia. So it's just like every day with Trump, you don't know what's going to happen. This is to be expected. We know that the process is going to and already is more difficult with the Trump administration, and memorialize that with the visa vetting executive order. Another policy which is disappointing to see the Trump administration revoke. And it'll be interesting if this continues to stay as a policy, because we have Vivek Ramaswamy and his AI policy advisor, which were pushing tech workers. And then they came out and they revoked a 10/30/23 executive order recommending policies to facilitate access to the O1, EB1, and EB2, and entrepreneur parole visa options. So we know that AI is the way of the future. It's going to make us more competitive as a nation. It's just surprising that this was revoked, because one of the reasons that we've advanced so much as a nation is because of the fact that we have the best and the brightest coming to the United States, and here this is revoking that policy, which was contrary to some of what his advisors recommended. It'll be interesting to see what will be happening in the future. All right, so let's dive into our questions now. All right, so let's see. We have a question here from EMS Construction. Will the 601A be impacted? Last time during the Trump administration, 601A continued to be processed. So far, I have not seen anything that says that it will be. I can't tell, into the future whether it will or will not be, but so far there's nothing that's targeting 601As. It did not happen last time. In fact, processing times have come down a little bit to about 38.5 months for the 601As. And we didn't see that last time, and we'll continue to have these updates here about the 601 and 601As. All right, we have another question here. How much would it cost me, all the legal fees of yours and the government, to convert my status to PR status, which is permanent resident status? So it really depends. There's so many different types of green card cases out there. So what I would recommend is you just contact our office at 916-613-3553. Tell us about what your case is about, and then we can give you a range of fees. Of course, it depends upon the difficulty of the case and whatnot, but there's green cards based off of family, marriage to a U.S. citizen or a parent, or there's green cards based off of a national interest waiver where you're doing something to benefit the nation as a whole under the employment-based second preference, or there's a green card off the EB1 category where you're outstanding in your field. So there's a number of different ways to get a green card. So I'd love to just learn more about your case. And just, again, you can give us a call at 916-613-3553. I know some of our J1 waiver clients might be wondering, how's it going to impact J1 waivers? Last time there was no impact on J1 waivers, except we saw more. With the Trump administration, we did see more requests for evidence. There was an increase in denials overall than normal. Not a huge increase, but it was more challenging. There was a higher increase for the request for evidence. So expect to see the same thing again. J1 waivers don't seem to be something that will be targeted. Of course, we don't know for sure, but there doesn't seem to be any particular reason that the Trump administration would want to go after that particular category. After filing the I-6-112 waiver, why do you need to file to the Department of State as well? So it depends upon the specific type of waiver that you're filing. So for the I-612, that's for a J1 waiver. So with the J1 waiver, for instance, like a J1 exceptional hardship waiver, which our office does many cases for, that you file I-6-112 with USCIS and with Department of State, because you have to have both agencies approve your case. I'm just going to give the exceptional hardship waiver as an example in that situation. USCIS has to give an initial recommendation, which they'll issue I-613 to the Department of State. Then the Department of State will look at the case and review the case as well. And then if you have a government sponsor, they'll get sponsor reviews to also evaluate whether or not your hardships outweigh the J1 two-year home residency requirement. So that's why you need to apply to both agencies in that situation. All right, well, I want to thank everyone for attending, and we will see you next week.